Okay, well, ciao everyone. I hope you grabbed your coffee and your notebook. Let's get settled in and get ready to hear the Condominium Board Certification class. This is a 4-hour class with a couple of breaks periodically. There's a lot to cover, and you will feel much better about your expectations of a Florida board member once you've completed this class. So the class does satisfy the law requirements for the condo board members, but not for the HOA requirements. CAMS, you will not receive a CEU credit if you didn't know, but it is important, surely, that you know what your board members are hearing. Boards, in addition to this class, you are also required to complete a course in a current legal update, a CEU course. So look for those classes in the next couple of months. It's a 2 or 3 hour class, depending on the attorney. There are no other CEU courses that satisfy the law requirements other than the legal update course for your board requirements. However, I do encourage you to attend the various other classes offered by myself and others and listen in and attend to gain all the knowledge and build your knowledge for your association. Your managers are listening to these CEU classes. They do get credits, but they also are gaining a lot of knowledge on building maintenance best practices. With that, I want to thank all of the board members today, and I also commend you all for becoming compliant with the law, taking your position of responsibility seriously. You must maintain your certification available to all residents for 7 years, and I suggest you create a file on your website to store them in, so these certifications are easily accessible by yourself and the residents in the years to come. So let's get started with some housekeeping tips. You must be signed in on the email address you registered with and stay on the webinar to get a certificate for a minimum of 3.5 hours. And this is being recorded for the DBPR records. Put your questions in the question box and put your comments in the chat box. And this goes for the sponsors that are on today, if you want to put your information in there, of course. But I want to let everybody know, following this webinar, I will be sending out a sponsor sheet. It'll have everyone's name, their title, their phone number, and also their email. So you can reach out to them following. So I want to thank and acknowledge today's sponsors that have invited you. These are all professional experience in the condo market and their respective product areas. The first sponsor I want to introduce this morning is Dawn Miller. She's a business development director at The Paving Lady. Dawn, tell us about yourself and your company, please.
Thank you, Peggy. Thank you, everyone, for being here with us today. I am the marketing director for The Paving Lady. We are an full-service asphalt contractor that's been in business since 1985. We do seal coating, asphalt overlays, asphalt patching. So it's rainy season coming up. So you might want to consider having us come out, evaluate your properties, see what liability issues you might have. And we suggest that you address them pretty quickly before they get worse. We also do striping and concrete curb and sidewalks. So I hope you guys enjoy the class, and I hope to hear from you soon. I'll leave my contact information in the chat box. Enjoy.
Okay, thank you, and good luck with your appointment. Next, I want to introduce the Vice President at First Citizens Bank. She's today's moderator. Lots of experience in condominium things, and former regional manager as a CAM. I want to introduce to you Jamie Gelfand. Jamie, tell us about yourself.
Hi, good morning. Thank you, Peggy. My name is Jamie Gelfand. I'm the Regional Sales Officer at First Citizens Bank, covering the Tri-County market. In CAB, Community Association Banking, we provide lockbox and loans to associations. So if your association is working on any of your milestone or SIRS reports, we can assist you in financing options. I'm also going to be the moderator for today's class. If you could please be sure to put your questions in the Q&A, because my chat option to reply to all is not working. So I wouldn't be able to respond to you if you're putting any comments in the chat. So please only use the Q&A. Thanks, Peggy.
Okay, you're welcome. And thank you for moderating. The next person I want to introduce to you is Damaris Cabrera. She's a business development manager at RMS Building Envelope Consultants. Damaris, tell us about yourself and the company.
Thank you, Peggy. Thank you, everybody, for joining us this morning.
You're muted.
Nope.
There you go.
You hear me? Okay.
Yeah,
Yes.
we hear you.
Okay, great. Thank you. Good morning, Peggy. Thank you, everybody, for joining us, and thank you for the invitation. I am the business developer for RMS. RMS is a building envelope consultant. We have a group of consultants with over 30 years of experience in the market. Our goal is to partner with managers and with owners to extend the life of the buildings. So we use technology as well, which is also is very efficient for the cost and these in these assessments, and we help to extend the life of the asset and to minimize the cost overall. So we'll be very happy to assist with any roof, building envelope, the consulting project that you see or foresee. And we also offer free advice. So feel free to call if you have any concerns. Thank you.
Thanks, Damaris. So next is Bob Aleka. Welcome, Bob. He is the Vice President of Community Association, and he is with Faster IO. Tell us about yourself and what you do.
Well, good morning, Peggy. Good morning, all. Bob Aleka here with Faster IO. We provide streaming TV and internet through our fiber optic system. We've been building, managing, and maintaining fiber optic systems for over 20 years, building and managing most of the service providers here in the state of Florida. And now we come to the residential space with our streaming TV, which allows you to take it with you, including changing your address and putting the zip code into wherever you go to get your locals as well as the national channels. We can provide up to 100 gigs symmetrical. That's 100,000 megs up and down. A little excessive, but to show you the future of the of your property without losing any speed or anything. Nothing is too small for us. 20 units and up. Please give us a call if you're in 2 years or so within your current agreement, or if you don't have agreement and you want to explore a possibly bulk agreement. Give me a call and we'll see what we can do. I'll put my information in the chat and enjoy the class.
Thanks, Bob. I always want to mention his partner in crime, Vice President of Marketing for Faster IO, Michael Zarin. He's very involved in the entire networking and so on. And if you can't reach Bob, you can always reach Michael, and his number will also be on the sponsor sheet. Next, I want to introduce Hafer Company. I'm not sure if they're on. Let me check. I'm looking for Mark Landez or Nicole Johnson. They're not on. Okay, thank you, Katie. They have 4 offices around the state. They are a full-service CPA company. They do auditing and, of course, day in and day out bookkeeping for you. So if you need a new source for that, please give either Nicole or Matt or Mark a call. Steve Mason is not on today either. He had commitments with Altieri Insurance Consultants. They do public adjusting. So again, his name will be on there as well. Next, I want to introduce the founder and CEO of COA Solutions, a commercial insurance specialist company, Daniel Baum. Daniel, tell us about yourself.
Thank you, Peggy. Good morning, everyone. As Peggy said, my name is Daniel Baum. I specialize in helping condominiums and homeowners associations save money on their commercial property and casualty insurance. What I'll simply say is this year, hopefully, if you're getting your renewals in, you're seeing a reduction in your commercial property policies. That's the big one. And that's the one that there's a lot more carriers in the market, a lot. There's a few more carriers in the market, but they are competing with each other and they are bringing down prices. I will say, though, on the general liability side and some of the other casualties like directors and officers, I've seen prices going up a little bit. Thankfully, those aren't quite as expensive. Simply put, if you are not seeing a reduction in your commercial property insurance this year, maybe we should talk about it, because it's possible that you're not getting the markets that you should be looking at, and you should be getting those discounts right now. They've been killing us for the last several years, so it'd be nice to see a reduction. I'll put my information in the chat if you want to reach out to me. I thank you very much and enjoy your webinar. Have a great day, everyone.
Thanks, Daniel. Next, I'd like to introduce Dahlia Anise Esquire. She's an attorney, and she has a firm that represents wills, trusts, and incapacity planning. Her company is Legacy Life Plan. Tell us about yourself, Dahlia, and what you do.
Thank you, Peggy. Again, my name is Dahlia Anise. I do wills, trusts, and capacity planning with Legacy Life Plan. But what I really do is I keep families out of court and out of conflict. When someone passes away and they don't have the right estate plan in place, their family have to go to court, and a judge who has no idea who they are is making very important decisions for them. Also, family conflicts. I know a lot of people say, no, my family, they love each other. But once someone passes, you really don't know what's going to happen. So the best thing is to do a heart-centered estate plan and spell out everything that you want. You'd be surprised what people fight over. Mom's toaster, that means so much to them. And so if this resonates with you, I would love to have a free consultation, a phone consultation. I will put my calendar link in the chat for you to click on and schedule a time for us to speak.
Okay, thank you, Dahlia. Motions get high during that time, so thank you for your service. Next, I want to mention Moshe Aronoff. He's a managing partner of Greener Path Retirement Planning. Great for looking into your finances if you need some help. Again, his name will be on the sponsor sheet. I don't see anybody on here either from City Quiet Windows and Doors. That's unusual. But Ben Friedman's the president. They have a couple of business developers out there that are great that can meet with you. But if you are in that project point and you need windows and doors, give him a shot. He has great products and great prices. Also not on the screen that I don't see is Rudy Forehand. He's the district manager for Benjamin Moore, national company down here in Florida, working with several distributors and providing great service for paint for your buildings. Next, I want to introduce Damaris Cabrera. She's a business development also for Clarkson and Varick elevator specialist. Tell us about yourself for the Clarkson Group.
Thank you, Peggy. Well, no, I'm back again. Our elevator consulting firm specializes in servicing and advocating for owners and property managers. So we basically ensure that the elevators are in compliance with the current codes, and we assist with projects from all the way from modernization, maintenance optimization, and we providing all that expert advice to the owners. We know that there is a bridge between in communication and expertise out there between the elevator companies that provide that service, that maintenance service, and the modernizations itself. So we wanna be that bridge for the owners and that advocate for the owners. I will drop. We provide a service. Is a free. I'm gonna drop the link for a free consultation to ensure that the people that is assisting to our webinar today can check their elevators whether they're compliant with the current codes. There are 2 current codes coming, so I will drop that link on the chat. Thank you, Peggy.
Okay, thank you, Damaris. Thank you. I want to also introduce now, they're not on, but the owners of J.R. Fraser Reserve Specialist Company, Sundeep J. and Patty J. They have a full service. They actually purchased that company after about a gentleman, J.R., that owned the business for about 30 years, but they are outstanding in their performance for Sears and any reserve study that you might need help with. Okay, next I want to introduce the wings beneath my wing. I want to introduce National Account Manager Rep for Vinteum Software. They're a website people specialists for condos. And Katie Bassford is on. Katie, tell us about yourself and what Vinteum does.
Yeah, thank you so much, Peggy, for that introduction. As Peggy mentioned, I am the National Account Manager, so I work with clients all across the U.S. Here at Vinteum, we specialize in HOA and condo management software. So we'll provide not only a public-facing website for your association, we'll also provide a private residence portal where you can communicate with your residents. You can store information like document storage, calendars, lots of great features there. And just so you know, it is totally compliant for those new community association laws in the state of Florida. We do follow those laws very closely. So if you are in need of a website and you need to get compliant with those upcoming laws, I would love to chat. I would love to get a free demonstration scheduled and really customize the best features for your community.
Great. And the newest feature, I believe, is electronic voting, isn't it?
Yes,
That's a
that
great
is our
feature.
feature that we kicked off in 2025. So yes, that
There
is
you go.
really exciting.
When I say wind beneath my wings, I cannot go without mentioning Hercules, the international marketing and sales manager, and also Julia. She's on today, the marketing manager who sets up all of our links and so on. So thank you very much. With that, I'm going to introduce Brian Barcelona. He's the president of Limestone Property Management. He's today's presenter. He is the president and a well-regarded company specializing in property and association management services. He holds a bachelor degree in communication from Broward College, and he is a licensed community association manager, and he also has a license in real estate. He's got over a decade of industry experience and driven. He's maintained his counts that he has of over 300 doors, and he oversees operations for his company, including policy compliance, budget management for associations, property valuations, and client satisfaction. So with that, I'm going to turn this over to Jamie Gelfand, our moderator, and Brian to get this going. So thank you so much, and let's get ready to rumble, huh?
Thank you, Peggy. And thank you, everyone, for attending the meeting today. As you know, so it's a 4-hour course, so we are going to be here for some time. But I'm going to try to make it as interesting as possible. And that way, you're not going to sit here and hear me speak for the next 4 hours straight. With that being said, I do see some people are putting in their names and things of that sort in the chat. I know when the meeting is over, I believe we're going to get a kind of like a report of everybody who attended. So if you're here, that's great. We'll get that. You'll get the credit for that. You'll get your certificate of completion within 3 weeks of completing the course. And of course, if you have any questions, put it in there. Jamie, she's going to help moderate this. So with that being said, the overview is we're going to make it so that way you have the essential knowledge and skills to run your condominium associations. Again, just repeating, this is just for condominiums. If you are in a HOA, this is not for HOA, so you're not going to get any credit for it unless you plan on moving to a condominium, of course. But it won't satisfy your homeowners associations. This is strictly for condominiums. We're going to cover budgets. We're going to cover reserves, the elections process, record maintenance, cover some of the best practice in records, bids, and of course, contracts. So here's some of our objectives. Again, we're going to understand the budgeting process for this portion of the meeting, legal requirements for reserve funds, best practices for managing associations, case studies, and examples. At this point, a lot of you we're all aware of CSRS and things of that nature, but it's a good reminder, I think, for a lot of people as well, especially if you're new to the board. This is going to be, you have to do it. So you're going to learn a lot by the time you're done with this meeting. So budget meetings, any meeting at which a proposed annual budget of an association will be considered by the board or unit owners shall be open to all unit owners at least 14 days prior to, shall be used in all unit owners. At least 14 days prior to the meeting, a board should hand deliver to each unit owner, mail to each owner the last address that was furnished to the association by the unit owner, or electronically transmit to the location furnished by the unit owner for that purpose a notice of such meeting and a copy of the proposed annual budget. An officer or manager of the association or another person providing notice of such meeting shall execute an affidavit evidencing compliance with such notice requirement, and such affidavit shall be filed among the official records of the association. So if a board adopts in any fiscal year an annual budget which requires assessment against unit owners which exceed 115% of assessments for the preceding fiscal year, the board shall conduct a special meeting of the unit owners to consider a substitute budget if the board receives within 21 days after adoption of the annual budget a written request for a special meeting from at least 10% of all voting interests. The special meeting shall be conducted within 60 days after adoption of the annual budget. At least 14 days prior to such special meeting, the board shall hand deliver to each unit owner or mail to each unit owner at the address last furnished to the association a notice of the meeting. An officer or manager of the association or other person providing notice of such meeting shall execute an affidavit evidencing compliance with this notice requirement, and such affidavit shall be filed among the official records of the association. Unit owners may consider and adopt a substitute budget at the special meeting. A substitute budget is adopted if approved by a majority of all voting interests, unless the bylaws require adoption by a greater percentage of voting interests. If there is not a quorum at the special meeting or a substitute budget is not adopted, the annual budget previously adopted by the board shall take effect as scheduled. So any determination of whether assessments exceed 115% of assessments for the prior fiscal year shall exclude any authorized provision for reasonable reserves for repair or replacement of the condominium property. Anticipated expenses of the association which the board does not expect to be incurred on a regular or annual basis, insurance premiums or assessments for betterments to the condominium property. If the developer controls the board, assessments shall not exceed 115% of assessments for the prior fiscal year unless approved by a majority of all voting interests.
Brian, can I interrupt for 1 second?
Yeah.
Can you please confirm if this class is credit for condominium only, or we have some people on the class that are HOA and co-ops?
Yes, this is just for condominiums, not for HOAs. It does not cover co-ops, so we're just going to be talking about condominiums. So if you are in a homeowners association, I mean, you will still get a certificate of completion, but that's not going to satisfy the requirement for you to have it for your homeowners association, because they're governed by two separate statutes. You have 718, 720. 718 is for condominiums, so we're just going to be discussing 718 in this meeting. There's another meeting for HOAs that covers 720, but we're not going to be touching that in this meeting.
Thank you.
So, and I'll do that, and I'll leave like some space because I'll start to ramble, and just if you have any questions, just ask away. So in addition to annual operating expense, the budget must include reserve accounts for capital expenditures and deferred maintenance. These accounts must include, but are not limited to, roof replacement, building painting, and pavement resurfacing, regardless of the amount of deferred maintenance expense or replacement costs, and any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. So I always like to kind of mention that point specifically because I've had clients who they will try to budget for certain items and they will, everybody wants to save a little bit of money. So if they could, cut back on reserves and let's say the elevator or even some windows around the property, then they'll do that. But it is pretty clear here, if it exceeds $10,000, you gotta, have a reserve for it. The amount to be reserved must be computed using a formula based upon estimated remaining useful life and an estimated replacement cost or deferred maintenance expense of the reserved item in a budget adopted by an association that is required to obtain a structural integrity reserve study Reserves must be maintained for the items identified in paragraph G for which the association is responsible pursuant to the declaration of condominium, and the reserve amount for such items must be based on the findings and recommendations of the association's most recent structural integrity reserve study. With respect to items for which an estimate of useful life is not readily discernible, or with an estimated remaining useful life of greater than 25 years, an association is not required to reserve replacement costs for such items, but an association must reserve the amount of deferred maintenance expense, if any, which is recommended by the structural integrity reserve study for such items. Now we're going to go into more detail about that. However, I just wanted to kind of say that when it comes to the reserve studies, typically it's anything over 3 stories that's required to have it. However, I'm sure there's a lot of people here who are in maybe 2-story buildings, and they're older 2-story buildings, and they're thinking, you know, should we get this done? My personal opinion, you know, you don't have to follow this, is that really you should. Most board members, in my experience, most managers, they're not professionals to tell you how much life you have in your building. They can't tell you how much lifespan you have in your roof or in the pool, whatever items you're reserving for. So it's good to have either an architect or somebody who's certified in structural integrity reserve studies, regardless of the size of your building, to at least get their eyes on it and tell you, hey, you have another 10 years or you have another 5 years, and give you their opinion. Because now you're not just basing it off of whatever your hunch or whatever past records you may or may not have, or things that you know we did do, but you know we just didn't record it in the minutes. You have a definitive opinion from a reputable company. The association may adjust replacement reserve assessments annually to take into account an inflation adjustment and any changes in estimates or extensions of the useful life of a reserve item caused by deferred maintenance. The members of a unit owner controlled association may determine by a majority vote of the total voting interest of the association to provide no reserves or less reserves than required by this subsection. For a budget adopted on or after December 31st, 2024, the members of a unit owner controlled association that must obtain a structural integrity reserve study may not determine to provide no reserves or less reserves than required by the subsections for items listed in paragraph G, except that members of an association operating a multi-condominium may determine to provide no reserves or less reserves than required by this subsection if an alternative funding method has been approved by the division, which to my knowledge, they have not. Reserve funds for any interest occurring thereon shall remain in the reserve account or accounts and may be used only for authorized reserve expenditures unless they're used for other purposes approved in advance by a majority vote of all the total voting interests of the association. I have a story about that, but let me finish this. Before turnover of control of an association by developer to unit owners other than the developer pursuant to statute 718-301, the developer controlled association may not vote to use reserves for purposes other than those for which they were intended. For a budget adopted on or after December 31st, 2024, members of a unit owner controlled association that must obtain a structural integrity reserve study may not vote to use reserve funds or any interest occurring thereon for any other purpose other than the replacement or deferred maintenance costs of the components listed in paragraph G. And I mentioned a little bit about the total voting interest of the association, because I've had board members who read this as total voting interest of the board, and they think that the board's decision, and they could, you know, how they want to spend the reserves, and if they all collectively agree that, you know, we're going to use some of our roofing reserves to do a repair in the painting or whatever it may be, then that's okay. But the statutes, and I've read these so many times, and they're consistently will say total voting interest of the association. If it doesn't say that, then of course take it up with your attorney. But if you see when it's saying specifically total voting interest of the association, that means all the members of your association, typically defined as an owner. Your condo doc will typically spell out exactly what is a member of the association. Sometimes it could be an owner or somebody that the owner appoints. They could be the member of the association. Sometimes you don't have that leeway. So just look in your condo docs as to what constitute a member of your association. The only voting interests that are eligible to vote on questions that involve waiving or reducing the funding or reserves or using existing reserve funds for purposes other than purposes for which the reserves were intended are the voting interests of the units subject to assessment to fund the reserves in question. Proxy questions relating to waiving or reducing the funding or reserves or using existing reserve fund for purposes other than purposes for which the reserves were intended must contain the following statement in capitalized bold letters in a font size larger than any other used on the face of the proxy ballot. So it has to be very obvious. I would even highlight it because somebody is going to say, I didn't see that. So highlight it because they will say they missed it. Waiving of reserves in whole or in part or allowing alternative uses or existing reserves may result in unit owner liability for payment of unanticipated special assessments regarding those items. And I think that would be good. People want to know that your chances of having a special assessment increase if you waive it, unless you like special assessments, but we all know nobody does. Structural integrity reserve studies, everyone's favorite topic. A residential condominium association must have a structural integrity reserve study completed at least every 10 years after the condominium's creation for each building on the condominium property that is 3 stories or higher in height, as determined by the Florida Building Code, which includes, at a minimum, a study of the following items as related to the structural integrity and safety of the building: the roof, the structure including load-bearing walls, and other primary structural members and primary structural systems as those terms are defined in statute 627-706. Just bringing out load-bearing walls could also mean the walls, and typically it would mean the walls inside the units. So yes, you will have to go inside the units, fireproof and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows and exterior doors, and any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000, and the failure to replace or maintain such item negatively affects the items listed in subparagraphs A through G, as determined by the visual inspection portion of the structural integrity reserve study. A structural integrity reserve study is based on a visual inspection of the condominium property. A structural integrity reserve study may be performed by any person qualified to perform such a study. However, the visual inspection portion of the structural integrity reserve study must be performed or verified by an engineer licensed under Chapter 471, an architect licensed under Chapter 481, or a person certified as a reserve specialist or professional reserve analyst by the Community Association Institute or the Association of Professional Reserves Analysts. I'm so glad they added that, because when this law first passed after that tragedy, it was only engineers and architects, and people had to wait years. They were not, maybe not years, because it has been years, but they had to wait a very long time to get anybody out there. But now, because they've included anyone who's approved by the Community Association Institute as a reserve analyst or Association Professional Reserve Analyst, they kind of opened the work pool for this, which of course has helped and helped drive down costs. So at a minimum, a structural integrity reserve study must identify each item of the condominium property being visually inspected. It must state the estimated remaining useful life and the estimated replacement costs or deferred maintenance expense of each item of the condominium property visually inspected. And it must provide a reserve funding schedule with a recommended annual reserve amount that achieves the estimated replacement costs or deferred maintenance expense of each item of condominium property being visually inspected by the end of the estimated remaining useful life of the item. Oh, I didn't set my timer. So I think we've been doing this for about 20 minutes or so. We'll take a break in 40 minutes. How are we doing, Jamie? Any questions?
Not at this time.
Okay, going on. The Structural Integrity Reserve Study may recommend that reserves do not need to be maintained for any item for which an estimate of useful life and an estimate of replacement cost cannot be determined. Or the study may recommend a deferred maintenance expense amount for such item. The Structural Integrity Reserve Study may recommend that reserves for replacement costs do not need to be maintained for any item with an estimated remaining useful life of greater than 25 years. But the study may recommend a deferred maintenance expense amount for such item. This paragraph does not apply to buildings less than 3 stories in height, single family, 2 family, or 3 family dwellings with 3 or fewer habitable stories above ground. Any portion or component of a building that has not been submitted to the condominium form of ownership, or any portion or component of a building that is maintained by a party other than the association. So that's kind of what I was saying from before. And yeah, I mean, again, if your building is 2 stories, even 1 stories, and it's been several years, you don't really have an idea of where your building stands, it can't hurt. And it's not, it's well invested. It's money you will get back because you'll know exactly what you need to budget for if you need to do any repairs, and it'll help you make a good schedule for your building. So that way in the future, you don't have to worry about special assessments because hey, we did our due diligence. We don't have to get a CERS inspection because we're less than 3 stories, we're 2 stories or whatever it may be, but it helps. It definitely couldn't hurt. And look at that. We flew through that first module. So now we're going on to elections. Introduction to condominium elections, overview of the election process, the legal framework, Florida Statute 718, the importance of transparent elections and maintaining trust within the community. And we all know elections should be transparent, right, folks? The members of the board of a residential condominium shall be elected by written ballot or voting machine. Proxies may not be used in electing the board in general elections or elections to fill vacancies caused by recall, resignation, or otherwise, unless otherwise provided in this chapter. This subparagraph does not apply to an association governing a timeshare condominium. I wonder how many people dropped off since we said it wasn't for HOA. So we still have a nice group of people. So at least 60 days before a scheduled election, the association shall mail, deliver, or electronically transmit by separate association mailing or included in another association mailing, delivery, or transmission, including regularly published newsletters to each unit owner entitled to a vote, a first notice of the date of the election. That is such a comprehensive sentence. A unit owner or other eligible person desiring to be a candidate for the board must give written notice of his or her intent to be a candidate to the association at least 40 days before a scheduled election. Together with the written notice and agenda as set forth in subparagraph 3, the association shall mail, deliver, or electronically transmit a second notice of the election to all unit owners entitled to vote, together with a ballot that lists all candidates not less than 14 days or more than 34 days before the date of the election. All these years and that the election process hasn't really changed. I personally still find that a lot of homeowners, they still get kind of confused with the entire process. I kind of see why, because there's so many paragraphs just explaining the election procedure, but it's 60 days is your first notice. Then and the 60-day notice tells you that basically you're going to have an annual meeting. It's going to have the location of the meeting. It's going to also include, it's not going to include who's going to be on the board yet. It's not going to give you the ballots yet. This is just your first notice. The first notice is 60 days. After that, people have 40 days to say, hey, I want to be on the board. I want to be the next sucker. I want to be the next volunteer to be on the board. afterward, after they put in their intent within those 40 days, then you get the second notice. That's 14. That goes out at the minimum 14 days before the meeting, but not more than 34 days before the meeting. So at a minimum of 14 days, the second notice goes out, and that notice is going to say, again, who's intending to be on the board. If they have a resume, which I think we're going to cover in the next paragraph, but it's going to give a breakdown of like their resume of what they want to be on the board. And of course, now you're going to be getting the ballot. So you could vote either by proxy. You could vote either at the time of the meeting. We're going to cover that some more.
I have two questions, Brian, if you
Yes,
don't
ma'am.
mind. One question is, what if my current board was elected by proxies?
That should be fine. I mean, if the proxies were, I mean, if all the owners, if the owners weren't going to be there and they all signed their proxies, and let's say they gave all their proxies to somebody who's going to be there, there's no limit to how many proxies somebody could have. So in theory, you can have, one guy who has 50 proxies, and then they pretty much decide who runs. That's possible. It just depends. I would still look at your condo docs to determine if there's any kind of cap on that. I haven't seen it. I wouldn't be surprised if it exists though. And then of course, any concerns, always go to your association's attorney. They'll tell you the best. And what's the next
And then
question?
I have two more questions that go back to the SIRS. Can you confirm when a SIRS needs to be completed, as I have been getting conflicting information? It is a 10-story building on the ocean. I was told by one firm that it should have been completed by the end of last year, and by another firm that it did not have to be completed until 25 years.
So I'm not sure what they were told. Obviously, I'm not there. It's very specific. We're trying to keep it general, because there was some wording, I believe, about whether, depending on somebody, if they just had their 40-year done or their 50-year done or not, then that kind of comes into play with their SIRS inspection. However, yeah, your SIRS inspection typically should have been done by now, because your 2025 budget should have taken the SIRS into account. So if you haven't done it, then you are in violation and you have to get that done as soon as possible.
Next question, is there any effort by the legislation to require adequate reserves for condos 2 stories or less?
They continuously omit 2-story condos, and I don't know, maybe they all own 2-story condos, but for the most part, from what I'm seeing, it typically is 3 stories or more. But that's kind of what I was mentioning from before, right? That even if you're not in a 3-story building and you are in a 2-story building, there are plenty old 2-story buildings that are 50 years old, and they were run by boards for they've been self-managed for years, so they never had professional management, and things are falling apart. So now what do we do? In those kind of cases, it couldn't hurt. That's what I'm saying. Like, you don't have to. You still don't have to. According to the statute, it said, it was for anything that was 1 to 4 dwellings, I believe it said, and then less than 3 stories, you don't have to do it per se. But it couldn't hurt to get it done. You could figure out where your building currently stands and kind of budget from there. In my opinion, if I'm paying any money, I want to know where my money is going. I want to know how the money is going to be spent, and I want to make sure that it's adequately reserved, so that way we're not finding ourselves in another special assessment, because it's not uncommon for some of these smaller buildings to be hit with a $2,000, $5,000, $10,000 special assessment, and they thought because they were in a small building they would be they'd be secure, they wouldn't have to worry about that, but it's happening everywhere at this point, so it couldn't hurt.
And legislation's in session right now, so we don't have any idea what they might propose for amendments or new laws that the governor may or may not sign towards May. So everyone should still pay attention to what's happening with the new laws. I have one more question. Clarify when computing next year's budget exceeds the 115%, are reserves and insurance excluded from both years' budgets?
Our reserves when computing for 2025 budget. Can you repeat that? I want to look at that question.
So please clarify that when computing that next year's budget exceeds this year's by 115%, are reserves and insurance excluded from both years' budgets?
Oh, yeah, that it was saying basically, so it's more like operating. So it shouldn't be because, and that makes sense because a lot of people, they either had no reserves and they're probably starting their reserves, or their reserves were so underfunded that now they got to dump in a lot of money to get it up to their cost of replacement. So because of that, the legislature probably figured, hey, look, people are going to be over 115% because they have to spend a lot of money to get them back to where they need to be. So let's make sure that it's 115% essentially for their operating. So, and then the reserves is not going to be included in that 115%. So if you're at if you're over 115% in your budget, but let's say it's because you had to increase your reserves by 80%, 90%. Well, you could take that out of there and then see how much you're left with, which would only be like, maybe 20, 30% increase, whatever it may be.
Great information. Thank you, Brian.
You're very welcome. And I just wanted to add, when you were talking about them being in session, that, yeah, we don't know what could come out of it, and it's changing all the time. So definitely, please, we'll keep our eyes out and see what else happens. It would be nice to see them include something for 2 stories, then they could all feel our pain. And I will say this, with insurance being what it is, in my mind, it would probably help the market if they said, look, now we're requiring that even 2-story buildings have to get it done, which could help drive down the cost, for everybody overall. It could help. I was gonna go back to I think I was here. Upon request of a candidate information sheet no larger. Yeah, because I did this and now we're here. Upon request of a candidate, an information sheet no larger than 8.5 inches by 11 inches, which is a standard letter paper, which must be furnished by the candidate at least 35 days before the election, must be included with the mailing, delivery, or transmission of the ballot, with the cost of mailing, delivery, or electronic transmission and copying to be borne by the association. The association is not liable for the contents of the information sheets prepared by the candidates. In order to reduce costs, the association may print, or duplicate the information sheets on both sides of the paper. I just want to touch on this because I recently had, it's not funny, but it kind of is, because someone in their information sheet, it was less of an information sheet and almost a scathing letter of the current board. And the board saw it and they're like, there is no way we're going to mail this out. But, I mean, 1, free speech. 2, it doesn't say anything in here that, oh, if somebody writes something mean, you don't have to mail it. It doesn't say that. It basically says that you're not liable for the contents, but you still have to mail it out. So they mailed this letter out. It didn't make much of a difference, in my opinion. I think most owners read it and were kind of taken aback by what was sent out. But it happened. So we're not focusing on the contents when we're sending out information sheets. We're just confirming, did we get it or not? We got it, great, and send it out. I mean, it was a very colorful letter. And, anyway, election procedures. So the division shall by rule establish voting procedures consistent with this subparagraph, including rules establishing procedures for giving notice by electronic transmission and rules providing for the secrecy of ballots. Elections shall be decided by plurality of ballots cast. There is no quorum requirement. However, at least 20% of the eligible voters must cast a ballot in order to have a valid election. And of course, you have to have enough people wanting to be on the board to have an election, which I think is covered in here too. But I'm saying that because sometimes you have a board of, let's say, 5, and your docs, it has to be 5 people, but then only 3 people run. Are we going to have an election? No, because you have less candidates than you do spaces. So there's no need to have an election. But if you had, say, let's say your condo docs have 5 spaces and then there's 6 people that put in their hat to run for the board, then you could then you'll have an election. And of course, you only have an election with at least 20% of the eligible voters. I always get a lot of questions in the election sections, Jamie. So if there's any questions, just let me know.
One just popped up as you said that.
Yep.
What are the consequences of failure to comply with all of these regulations?
I mean, now it depends. And I say that because it depends, and I'm not an attorney, I'm not a prosecutor, but from what I've seen in the industry, it depends in what caused it. Were they deliberately not having a meeting so that way they could stay in power longer? It's always hard to prove intent, I will say that, but that does play a huge part of it. There are some associations where the board, I had an experience where the current board stepped down during election time. There's a few that left, but they had to quickly get everything back together, back in order. And when they did, they had to have their annual meeting in December, but by the time they had their interim board, it was like November. So as you could tell, there was no way for them to do that 60-day notice. So as soon as they were back in the position where they could have the annual meeting, they had the annual meeting. So there's a lot of factors that come into play. I'm not going to sit here and say it's a felony and they're gonna go to jail or they could be fined. I can't say all that. I know some people probably want to hear that. They would love to hear that, but I can't say that. It just depends. And that's something you may have to speak with your attorney about. But there's so many factors when it comes to these kind of things.
So he wanted to clarify to say, I mean, all regulations, not just pertaining to elections.
So if you're having a board that's running the association and not following any of the statutes, they're breaking the law. So take what you'd like to do with that information, but that's against the law. They're breaking the law. There are clear procedures in place. There are clear statutes in place for the protection of homeowners. When you join your board of directors, you're taking a fiduciary role on behalf of the owners. So you're not there for your best interest. You're there for the interest of all. And if you're deliberately breaking it, then yes, there are consequences. And again, it's against the law. So file a police report. You could call the ombudsman to do an investigation. You contact the DBPR to do an investigation. If there's a cam involved, there are things that you could do, and they will escalate it and investigate it to confirm what's happening. There was it wasn't too recent, but wasn't just last year. There's a bunch of people in Miami who got arrested because it was similar stuff. They were getting kickbacks. They were, it was something like out of Scarface. I'm not saying that because of Miami, but maybe I am. And they got there. I think they were arrested for it. So again, I'm not saying do that, but there are laws for a reason. If you're breaking the law, there's consequences.
Thank you. That's all I have for now. Oh, wait, lied.
I'm making good time, so I speak very fast.
What determines the amount of board members in an association?
Yeah, so by law, you have to have at least a president, a treasurer, and a secretary. That's what makes up the association. However, your condo docs will specify how many you need to have. Typically, again, you'll see just those 3. You can't have a 2-person board. You can't have a 1-person board. But typically it's just the minimum, that 3: president, treasurer, secretary. And then look in your condo docs to tell you how many you can have, how many you must have, things of that sort. A unit owner who violates this provision may be fined by the association in accordance with 718-303. A unit owner who needs assistance in casting the ballot for the reasons stated in Statute 101-051 may obtain such assistance. The regular election must occur on the date of the annual meeting. Notwithstanding this subparagraph, an election is not required unless more candidates file notices of intent to run or are nominated than board vacancies exist. And then footnote, requirement for an election to be valid if at least 20% of eligible voters cast the ballot. And that was kind of what I was saying before. If you have less candidates than you do spaces, you don't have an election. If you have more candidates than you do spaces, so if you have 6 people running on a board that only seats 5, then you have an election, and you have to make sure you have at least 20% to cast a vote to have an election. Board member education, and this is what we're doing right now. A director, and I'm looking at my clock. That's why I keep looking at this. I have 2 screens, by the way. So a director of a board of an association of a residential condominium shall 1, certify in writing to the secretary of the association that he or she has read the association's declaration of condominium, articles of incorporation, bylaws, and current written policies, that he or she will work to uphold such documents and policies to the best of his or her ability, and that he or she will faithfully discharge his or her fiduciary responsibility to the association members. And then 2, submit to the secretary of the association a certificate of having satisfactorily completed the educational curriculum administered by the division or a division-approved condominium education provider. The educational curriculum must be at least 4 hours long and include instruction on milestone inspection, structural integrity reserve studies, elections, record keeping, financial literacy and transparency, levying of fines, and notice of meeting requirements. So we're currently right here in elections in this timeline. So we got a little bit more to go. We got 20 more minutes before our first break.
And
Chuck,
I have 2 questions.
Yes, ma'am.
If there are 5 people on the board, can the president also be the treasurer?
No. No to that. That's an easy one. The treasurer, the president could be you could have, if you're gonna be dual roles. I mean, if you have 5 people, I mean, come on, like somebody step up. But you could have like a president who's also a secretary, but you can't have a president who's also a treasurer. They're controlling all the money then. You don't want that.
Next question. A couple of years ago, the rules changed for how long you can sit on a board. If I have been on the board for 6 years and the new rules came into play, does the clock reset to do my original 6 years count towards the total of number of years I can serve?
So I know what law she's referring to, because I believe it says 8 years. And we're going to touch on that in here too, but it was 8 years, and I don't remember the exact starting date, but it had a certain year and month, and 8 years from that is how long you could be on the board. Now in that law, it does say consecutive. I remember that. So if it's consecutive. So it's if you're it's not saying you can only be in 8 years in total, but if you could do a year here, a few years there, take a break. That's okay. Or step off the board, come back onto the board. Then that's fine. But it just, when we get to that point, I'll remind me of this question, so then we could kind of talk about that specifically. But really, even at 6 years, I believe it was 8, so that should be okay. And also, by the way, that only depends on whether or not you have anybody else who's trying to be on the board. Because there's been situations, in my experience, again, where nobody wants to be on the board, and somebody's been on the board for, let's say, 10 years, but if they run unopposed, and or it's the same people going on the board and nobody wants to run for the board, then they're just going to stay on it and just until one of them decides to step off. But let's say somebody does decide to step on, then in this case, if you broke that consecutive, those consecutive years, right? Let's say you've been on your condo board for 7 years, for 9 years, and now somebody's going to run. Well, you can't be included on that election because you already have, let's say, 9 years consecutively. I don't think this lady has that because she's only been, like you said, 6 years, but it depends if she has other people running against her or not. That's another thing she has to think about.
So a few more questions, but they're showing up in the chat, and I'm just going to ask everyone if you could please make sure that you're putting your questions in the Q&A box so that they get timely attended to. So here's a couple for you, Brian. Can anyone besides the president hold two positions, i.e. vice president / treasurer, when it's a 3-person board?
Yeah, that's fine, but again, it wouldn't, if a 3-person board, you have to have president, treasurer, and secretary. So you could have, I have a client where you have a treasurer, secretary, and then you have a president. So there's 2 different roles, president, secretary, treasurer, secretary, and a president, and then one of them is a vice president. So you could do that. If you want to do vice president and treasurer, you could do that, I'd say as well. Again, look in your docs, ask your attorney. Shouldn't be a problem, I would say, though.
What department in the state do you report to if there's voter fraud?
That's the ombudsman, I believe. That goes to the state ombudsman for condominiums, and then they'll come down and investigate it. Or you go straight to the DVPR, and they'll investigate that as well.
How often does a board member have to meet the educational certification requirement? Is it annually, board term, or only once?
So, and we're going to touch on that too. But after this course, so after you do your 4-hour certification course, you do have to do an annual 1-hour CE course. So every year you're going to have to take one more, take one educational course. And what it is specifically, I'm honestly not 100% sure. It's because I know for CAMs, we have to take one, but board members will have to do it as well. Peggy has a question.
No, I just want to make a comment. 2 things. First of all, if you have any questions that no one who is not an attorney can't answer, contact your attorney or your association, and they will definitely, lay it out what the different laws are specifically to your question. The other thing is, I do know for sure that it is definitely a legal update class. So not just any old CEU class can be taken. It must be a legal update class along with your certification like today. So
Thanks.
that's it.
Thanks, Peggy. So yeah, one legal update course per year. So, speaking of the devil, each newly elected or appointed director must submit to the Secretary of the Association the written certification and educational certificate within 1 year before being elected or appointed, or 90 days after the date of the election or appointment. A director of an association of a residential condominium who was elected or appointed before July 1st, 2024, must comply with the written certification and educational certificate requirements in this subparagraph by June 30th, 2025. So if you were elected to your board before July of last year, you have a little bit more time to do it. But anybody after July 1st, like if you just had your annual meeting this past, December or these last few months, or after July 1st, you have 90 days to get your 4-hour course done. The written certification and educational certificate is valid for 7 years after the date of issuance and does not have to be resubmitted as long as the director serves on the board without interruption during the 7-year period. A director who is appointed by the developer may satisfy the educational certificate requirement in subparagraph 2 for any subsequent appointment to a board by developer within 7 years after the date of issuance of the most recent educational certificate, including any interruption of servants on the board or appointment to a board in another association within that 7-year period. 1 year after submission of the most recent written certification and educational certificate, and annually thereafter, a director of an association of a residential condominium must submit to the Secretary of the Association a certificate of having satisfactorily completed at least 1 hour of continuing education administered by the division or a division-approved condominium education provider relating to any recent changes to this chapter and the related administrative rules during the past year. That's kind of in line with what Peggy was saying. So every year you have to take 1 hour and update on the laws. Did you have anything else to say, Peggy? Because your hand's still up. Yes, no, maybe? Okay, just making sure. You know, she's a matriarch of this whole thing, so I got to keep her happy. A director.
I told you to tell jokes, excuse me, but not on me.
Oh no, it was a compliment.
Oh, thank you. Okay, but
It was a compliment. Really, she's been doing this for a long time. It's incredible to see this still going on. Kudos to you. Any questions while we're bantering, Jamie?
Not at the moment.
Okay. Still making good time. A director of an association of a residential condominium who fails to timely file the written certification and educational certificate is suspended from service on the board until he or she complies with this subparagraph. The board may temporarily fill the vacancy during the period of suspension. The secretary shall cause the association to retain a director's written certification and educational certificate for inspection by the members for 7 years after a director's election or the duration of the director's uninterrupted tenure, whichever is longer. Failure to have such written certification and educational certificate on file does not affect the validity of any board action. Any challenge to the election process must be commenced within 60 days after the election results are announced. So filling vacancies. Unless otherwise provided in the bylaws, any vacancy occurring on the board before the expiration of a term may be filled by the affirmative vote of the majority of the remaining directors, even if the remaining directors constitute less than a quorum, or by the sole remaining director. In the alternative, a board may hold an election to fill the vacancy, in which case the election procedures must conform to subparagraph 4A, unless the association governs 10 units or fewer and has opted out of the statutory election process, in which case the bylaws of the association control. Unless otherwise provided in the bylaws, a board member appointed or elected under this section shall fill the vacancy for the unexpired term of the seat being filled. I also had that same thing happen to me recently too. Basically, more than half the board stepped down like abruptly, and there was only like 2 people left, and they were like completely panicked. So now what do we do? I'm like, well, you got to get more people, because according to statute, even if there is one board member, the sole remaining director, the lone wolf, they could fill the vacancies. So they did. We got 4 more people, and all is well. Of course, it was a duly appointed meeting, and we had an organizational meeting and all that stuff, but it's good to know. This chapter does not limit the use of general or limited proxies, require the use of general limited proxies, or require the use of a written ballot or voting machine for any agenda item or election at any meeting of a timeshare condominium association or non-residential condominium association. That kind of touches base on what somebody else was asking about. Can somebody just vote by proxies? Like, there's not really a limit to how many proxies somebody could hold. So notwithstanding subparagraph B2 and subparagraph 4A, an association of 10 or fewer units may, by affirmative vote of a majority of the total voting interest, provide for different voting and election procedures in its bylaws, which may be by a proxy, specifically delineating the different voting and election procedures. The different voting and election procedures may provide for elections to be conducted by limited or general proxy. Voting interests. The only voting interests that are eligible to vote on questions that involve waiving or reducing the funding of reserves or using existing reserve funds for purposes other than purpose for which the reserves were intended are, sorry, I got distracted. or using existing reserve for purposes other than purposes for which the reserves were intended, are the voting interests of the units subject to assessment to fund the reserves in question. So that's the kind of the key word here, are the units subject to assessment. Sometimes I think particularly here in Florida, because I had something where there was association, there was a docks, right? Only a few people own their boat slips. So, you know, they kind of got they were the ones who were voting on the special assessment for their boat slips. And some of the owners who didn't have a boat slip, well, they wanted to chime in. And according to this, well, they're not subject to the assessment. So they don't really have a vote. If you're subject to the assessment, you have a vote. If not, you got nothing. Section 718. Somebody raised Jamie, yes?
A question came in. I have a board member who is not taking this 4-hour class because they were selling their unit after season. Do I have to remove them now, or can I let their term expire?
Well, it said, you know, if they don't do it within 90 days, then they're suspended until they do it. Until they do their course, they're suspended. Carmen, is there a Carmen who's asking a question?
I have another question.
Mm-hmm.
I don't know who Carmen is, but I
I
have a
keep
different question.
I keep seeing a hand raised for a Carmen. But go ahead, sorry.
I was sent a paper to sign that says that I certify that I have read the association's declaration of condominium, articles of incorporation, bylaws, and current written policies. If my building was built in 1969, do all of these documents exist? And if so, where do I find them?
I mean, that form, I mean, like I said, I haven't seen it. I don't know. That may be a question for your manager or your attorney. I haven't seen anything what they're referring to, but it sounds like they got a paper that says they read their docs and they read their rules and regulations, and they want to know if there's like one specific to their association, I guess, and if there's an original from when the association was built. If that's what they're trying to say, in my opinion. And again, this is my opinion. You don't have to take anything I say here as Bible, or I'm not an attorney, I'm not doing any of that. But if that's what they're trying to say, then it's not really specific to your association, this form. It could be a handwritten note that says because all it said was you just need to write that you approved, that you read the rules and regulations, that you're going to uphold your fiduciary duty, and it has to be signed by you. So if that's on a piece of paper, if you typed it up, that's fine. You may want to put it on like the association letterhead, make it look kind of pretty, but you don't get any extra points for aesthetics. As long as we know that you, of course, took your CE course, which you're doing now, so you get your certificate and you're signing off that you read your rules and regulations, you read your association docs, and you're going to do your best to uphold these rules in your fiduciary duty. And sounds good.
And their attorney, so part of her question was, where do I find them all? The association should be providing them to her, and or the association's attorney, who would have the copies of the original recorded deck in the courts.
I mean, what did it say? Like they have to retain it for 7 years, these documents. So if you still have your board from when the association was first built, good luck. But really, it's 7 years. Yes, Peggy?
Well, you sort of alluded to it, but I was just going to comment that that is no longer valid. Just signing off that,
No.
That is no longer valid. That's why they created this law, to further educate you. And also, this covers not just your documents, it covers the law for training. So there's a very, very big factor. I mean, I've never seen as many things pass as there were last year, effective July 1st, all the way in many cases. Many laws related to what board members need to know. So that's why they really want everybody every year, if you can, to take a legal update and, just keep abreast of what the law is so that you don't have to use your D&O insurance, or maybe you make a mistake that you can't use your D&O insurance. So boards do get sued, and you have to stay compliant and you have to stay knowledgeable. So, but you can't sign off anymore. That's old hat.
Mhm. Yeah, that's part of it. You have to do both, sign off and do the CE course. And my timer just went off. So I think we'll probably finish this section. I don't know, how do you feel, Jamie? We make a great team, you and I.
I agree. I have one more question.
Yes.
We only have 24 units and no one wants to be on the board. If we can't get anyone on the board, what is the consequence?
Well, I mean, in those kind of cases, they go to receivership, right? You can't get a board. So, and receivership is basically, it's a process and it's expensive because the association has to foot that bill. But essentially, a court will appoint typically an attorney to run your association, and they're going to be doing the checks and balances, and they're going to make sure that the association is still running, and they're going to charge you by the hour, and an attorney would charge. So I think it behooves you to get someone, at least 3 people, at least a president, treasurer, and secretary. Read your docs because it will specify clearly, but at least start with that to be on your board of directors.
The unit owners need to understand the value of their property and the importance of having a board to ensure that the property is being properly maintained, the value of their property is being kept up, and that the laws and requirements under the declaration are being followed. So it's a lot about education.
Yeah. It's so funny because, I find that people with condominiums, they'll spend sometimes seemingly no limit to make their condo look beautiful. And you'll redo the bathroom, you redo the kitchen, you put in new appliances, you put in new cabinets, you do the whole 9 yards. But then they don't want to touch anything outside. They don't want to do the roof. They don't want to be on the board of directors. They let everything kind of wither around them. It's so funny to me, the psychology behind that, because if you're going to put money, like you said, you want to maintain your values, right? So that's why you buy property. You want to make it look nice, but in a condo, you can't just think about your unit. You got to think about the bigger picture. You got to think about the building. Is the building, let's start with, is it structurally safe? Is the roof good? Is the SIRS done? Has it been budgeted correctly? And then kind of go from there. And that's why that's why people hire management companies in the first place, because when you realize that there is a lot of moving parts to this, maybe we do need to bring some professionals on our side to kind of help us navigate all these laws and statutes and even owners and board members and elections. It could be a lot.
One more question, not really sure it pertains to this class, but in any case, it was a question. We are pet-free according to our docs, but members of the board have cats and dogs. Some want the rule changed, but as of now, it has not been completed in the docs. What do they do?
I was laughing because after all, like, pets are always such a sour spot, like all the time. And again, it really just depends. Are they service animals? Are they support animals? There's nothing that says you can't have a support animal and a service animal. So it really just depends. But if somebody's breaking the rules, then it's handled the same way. They get a violation letter, remove the pet, remove the whatever, and then escalate it from there. Look in your rules and regulations, look at your condo docs. Of course, it should spell out the steps that you could do if somebody's breaking the rules. And if you have a violation committee, that's just more punitive damages that you could do, because then you could violate them and give them, some monetary fine if they don't remove the pet within so many days. I find pets are such a, it's so interesting. It's tough because, you know, again, typically if somebody has a pet, if I have a dog in my unit and you say, hey, remove your pet, I'm just going to hit you with a letter that says it's emotional support. And then you're kind of in the gray area again. The whole concept is so funny to me because isn't every pet an emotional support animal? Nobody get
Exactly.
like nobody gets a pet to not support them emotionally. Like I want my life miserable, I'm gonna get a dog. That's not how it works. But such is life. I think. What do you think? You want to finish this section, or should we pause here? Because we've been doing this for a little bit more than an hour now.
How long is the section?
Let me see. There's probably a few more slides. I don't know how to jump too far ahead. There's a total of 73 slides. We're at 34. So we're
I
a
think
little
we
more.
should pause.
Actually, this is the last slide, and then we have a new module. So I'm just going to read this, and then we'll start
Perfect.
module 3. So proxy questions relating to waiving or reducing the funding of reserves or using existing reserve funds for purposes other than purpose for which the reserves were intended must contain the following statements. Wait, I did that already. Did I do this already? Oh yeah, no, I read that. So we are done. We're on module 3. Great. So I think we could take a break there. We're still making good time. So you want to come back in say 10 minutes? All right.
Perfect.
I see Peggy nodding. So 10 minutes it is. All right, folks. See you in 10 minutes. Stop sharing. I'm going dark.
Brian, you're muted. Once everyone comes back, 2 questions came in the chat before you get started, and you're still muted, Brian.
Okay. Hear me now?
Yes.
Good.
So before you get started, I'm not sure you heard me, but before you get started, 2 questions came in the chat during the break.
Okay.
Ready?
Yes, ma'am. Let me share my
Okay.
screen so we get started as soon as we're done with this.
Brian previously mentioned electronic voting. If it is not expressly permitted in the current documents, do the documents require amendments to allow electronic voting?
Yes, if your docs, I mean, if it says, you say expressly, like expressly. So if it's not specifically said, if it says specifically electronic voting is not permitted, then you do have to amend it to say electronic voting is permitted. And then you could do electronic voting. Although that would be interesting. I have not seen a docs that specifically say electronic voting is not allowed, but it's possible.
Right. So if it doesn't state that it's not allowed, then it is allowed and they don't need to do anything to their declaration, correct?
Correct.
Okay, good. Interesting question. Next one. How difficult is it to change from a condominium association to an HOA? Not sure why someone would want to do that.
Yeah. I mean, I guess it all comes down to the voting interest, right? Like that's definitely a question for your attorney. I'll say
Right.
that for
Because
sure.
your declaration was set up as a condominium, so
Yeah.
I would agree with you. That's an attorney question.
Mm-hmm. There's a lot of moving parts to that one.
Absolutely. Okay, back to you.
Thank you, ma'am. I'm back with a costume change. In case anybody noticed. So now we're going to go on to records maintenance. So to ensure board members understand their legal responsibilities regarding the maintenance and accessibility of association records. Defining official records. So official records are from the inception of the association shall maintain each of the following items, if applicable, which constitutes the official records of the association. A copy of the plans, permits, warranties, and other items provided by the developer under Statute 718-301, subsection 4. A photocopy of the recorded declaration of condominium of each condominium operated by the association and each amendment to each declaration. A photocopy of the recorded bylaws of the association and each amendment to the bylaws. A certified copy of the articles of the incorporation of the association or other documents creating the association and each amendment thereto. A copy of the current rules of the association. Defining official records continued. A book or book that contains the minutes of all meetings of the association, the board of administration, and the unit owners. A current roster of all unit owners and their mailing addresses, unit identifications, voting interest, voting certifications, and if known, telephone numbers. The association shall also maintain the email addresses and facsimile numbers of unit owners consenting to receive notice by electronic transmission. In accordance with subparagraph C5E, the email addresses and facsimile numbers are only accessible to unit owners if consent to receive notice by electronic transmission is provided, or if the unit owner has expressly indicated that such personal information can be shared with other unit owners, and the unit owner has not provided the association with a request to opt out of such dissemination with other unit owners. An association must ensure that the email addresses and facsimile numbers are only used for the business operation of the association and may not be sold or shared with outside third parties. If such personal information is included in documents that are released to third parties other than unit owners, the association must redact such personal information before the document is disseminated. However, the association is not liable for any inadvertent disclosure of the email addresses or facsimile number for receiving electronic transmission of notices, unless such disclosure was made with a knowing or intentional disregard of the protected nature of such information. All current insurance policies of the association and condominiums operated by the association. A current copy of any management agreement, lease, or other contract to which the association is a party or under which the association or the unit owners have an obligation or responsibility. Bills of sale or transfer all property owned by the association. Oh, I did not, whoops. Sorry about that. Trying to set my timer. Oh no. While I'm at it, let me just set my timer. Sorry about that. Did elections, we are back to here. Oh, give me a break. Okay, here we are. So back to define official records, accounting records for the association, and separate accounting records for each condominium that the association operates. Any person who knowingly or intentionally defaces or destroys such records or other knowingly or intentionally fails to create or maintain such records, landscapers, with the intent of causing harm to the association or one or more of its members is personally subject to a civil penalty pursuant to statute 718-501 1E. The accounting records must include, but are not limited to, accurate, itemized, and detailed records of all receipts and expenditures, all invoices, transaction receipts, or deposit slips that substantiate any receipt or expenditure of funds by the association, a current account, and a monthly, bi-monthly, or quarterly statement of the account for each unit designating the name of the unit owner, the due date and amount of each assessment, the amount paid on the account, and the balance due. All audits, reviews, accounting statements, structural integrity reserve studies, and financial reports of the association or condominium. Structural integrity reserve studies must be maintained for at least 15 years after the study is completed. And it has not been anywhere near 15 years since they enacted this law. So if you have it, you definitely have to keep it and make it available to anybody who requests it. No way. All contracts for work to be performed, bids for work to be performed are also considered official records and must be maintained by the association for at least 1 year after receipt of the bid. Ballot sign-in sheets, voting proxies, and all other papers and electronic records relating to voting by unit owners, which must be maintained for 1 year from the date of the election, vote, or meeting to which a document relates, notwithstanding paragraph B. All rental records, if the association is acting as agent for the rental of condominium units, a copy of the current question and answer sheet as described in statute 718-504, a copy of the inspection reports described in statutes 553-899 and 718-301, subsection 4P, and any other inspection report relating to a structural or life safety inspection of condominium property. Such record must be maintained by the association for 15 years after receipt of the report. Bids for materials, equipment, or services, all affirmative acknowledgments may be made pursuant to statute 718-121-4C. A copy of all building permits, a copy of all satisfactorily completed board member educational certificates, all other written records of the association not specifically included in the foregoing, which are related to the operation of the association. So I want to say these are very comprehensive laws, as I think people could see. I always say it's a lot shorter to talk about what you can't provide, like what's not an official record, because it covers almost everything. Any questions, Jamie? Oh, I can't hear you. You're muted.
Sorry, just one I was answering, but you can answer it as well. What is your opinion on having a treasurer on the board for a long period of time doing the books? There were issues a couple years ago. Now he states the books are correct, but owners don't believe it.
Again, very, very specific. So I would say, I mean, there's nothing wrong with somebody being a treasurer for years. If nobody else wanted to do it, great, you know. But also this depends on the size of your association. I say that because you should be getting audited. So do you have audited financials? Do you have reviewed financials? Because depending on how much income the association brings, I believe the threshold is like 300,000. So under 300,000, you should have like reviewed financials, which is an independent auditor. Over, then you have to get audited by an independent third party. That was completely unrelated. I was just asking because we're still making good time.
And all owners are then provided copies of those reports.
Yeah. And those reports are provided without them requesting it. So when it's done, I think they have 90 days to get it out to the owners. Like when it's completed, they have to send it out to all owners. And they don't, well, let me correct, because they don't have to send out a copy of the report, but they have to send out notification to all the owners that report has been completed. If they would like a copy, they need to get it. You know, they could request it and they could give it to them.
And depending on the size of their association, they also need to have a website. And all of these documents should be provided on their website with owners' access to the website.
That's right. And you should have kind of like Vietnam, the vendors here we're referencing, like you have a public one and then you have a closed website just for owners where they have access, you're right, to all their financials and, you know, budgets, proposals, whatever it may be. Even though it's only there for 1 year, I'm in the camp where there's no secrets in associations. Put it all out there.
Agree.
Section.
I have one more question. Are regular monthly resident meetings required?
They're quarterly now. Minimum quarterly, and you have to have a section in your rules, like in the meeting. There has to be a portion in there that says unit owner comments. So you have to now include, so now you have to meet by minimum once per quarter, which I think we're going to cover here. And then you also have to include a portion, like a section in the meeting for owners' input.
I have another question. We passed a special assessment in the amount of $8,300 per unit. All monies were collected. The actual costs were less than the items listed in the special assessment. If most owners have verbally said to put it towards the next assessment, in order to legally account for this, does the board have to hold a regular board meeting or a special meeting with the majority ownership vote to officially vote on using the surplus funds towards the next special assessment or refund that amount of unused special assessment to each owner? We have two big assessments on the horizon. One owner has expressed, sorry, my dog is barking, someone's knocking at the front door. One owner has expressed that the money should be refunded unless there is a formal vote to put unused funds towards the next assessment.
Well, I mean, I would say it probably was probably something that should have been discussed before the meeting, which I guess it's said and done, which is why they're asking that question. They may want to ask their attorney again as to what they could do. My experience is one or two things could do. One, definitely have to have a vote on it, because once again, when you pass a special assessment, those funds are only to be used for that special assessment. So it could either get absorbed in the association and you could put into operating and whatever it may be, or you could vote to refund the owners back. But verbally saying it would not be enough. definitely I would recommend having another meeting and vote on it. So, hey guys, we have this much money left. Do you want a credit on your account? Which I would probably recommend versus sending a whole nother check. That's just more accounting fees. Just give people a credit, or should we just put the excess back into operating? Or put it into reserves for the items they just worked on?
Next question before you get started. We have a group chat between owners. Is that legal? Can board members take part in communicating with the ownership through the group chat?
Again, I mean, that's an attorney question. Like if it's legal or not, I can't really say. So I can give you my opinion, which it does say you can't have a quorum of board members, like talking about association business outside of board meetings. But that's an attorney question for their attorney.
Back to you then.
Thank you, ma'am. So the official record specified in subparagraph. Oh, but I will say one last thing about that question. A lot of people though have they have like a WhatsApp group or a Facebook group of just owners. I don't think that's an issue. But anyway, I digress.
Right, as long as there's no motion being had there or intend to make a decision, they can all talk amongst themselves.
Yeah, I mean, it's owners, like neighbors talk all the time. I have a Facebook group for my association, which I'm not part of because I do this. I would not want to be involved. But
I'm not on my board. I'm not on my board either.
Right? The official record specified in subparagraph A1-6 must be permanently maintained from the inspection of the association. Bids for work to be performed or the materials, equipment, or services must be maintained for at least 1 year after receipt of the bid. All other official records must be maintained within the state for at least 7 years unless otherwise provided by general law. The official records must be maintained in an organized manner that facilitates inspection of the records by a unit owner. In the event the official records are lost, destroyed, or otherwise unavailable, the obligation to maintain the official records includes a good faith obligation to obtain and recover those records as is reasonably possible. And then records must be maintained in an organized manner that facilitates inspection. I just want to say that's a huge one because a lot of associations, especially the older buildings, ones built like the 70s, their record retention is so. Anyway, yeah, their record retention needs work nonetheless. And I get it, they've been through a lot of hands and it's still hot. And so things get lost, but you definitely want to get some kind of company in there to help clean up your records. Otherwise, you may be in breach of this statute. It has to be in an organized manner that facilitates inspection. So just having boxes and boxes and boxes and loose paper everywhere may not be the best way to restore your records or to keep your records if you have it that way. Section 718, 111, 12, the records of the association shall be made available to a unit owner within 45 miles of the condominium property or within the county in which the condominium property is located within 10 working days after receipt of a written request by the board or its designee. However, such distance requirement does not apply to an association governing a timeshare condominium. This paragraph and paragraph C may be complied with by having a copy of the official records of the association available for inspection or copying on the condominium property or association property, or the association may offer the option of making the records available to a unit owner electronically via the internet as provided under paragraph G, or by allowing the records to be viewed in electronic format on a computer screen and printed upon request. The association is not responsible for the use or misuse of the information provided to the association member or his or her authorized representative in compliance with this chapter, unless the association has an affirmative duty not to disclose such information under this chapter. And footnote, the association must make records available within 10 working days after receipt of a request. The official records of the association are open to inspection by any association member and any member authorized by an association member as a representative of such member at all reasonable times. The right to inspect the records includes the right to make or obtain copies at the reasonable expense, if any, of the member and of the person authorized by the association member as a representative of such member. A renter of a unit has a right to inspect and copy only the declaration of condominium, the association bylaws and rules, and the inspection reports described in Statute 553-899 and 718-3014P. The association may adopt reasonable rules regarding the frequency, time, location, notice, and manner of record inspections and copying, but may not require a member to demonstrate any purpose or state any reason for the inspection. The failure of an association to provide the records within 10 working days after receipt of a written request creates a rebuttable presumption that the association willfully failed to comply with this paragraph. A unit owner who is denied access to official records is entitled to the actual damages or minimum damages, or minimum damages for the association's willful failure to comply. Minimum damages are $50 per calendar day for up to 10 days, beginning on the 11th working day after receipt of the written request. The failure to permit inspection entitles any person prevailing in an enforcement action to recover reasonable attorney fees from the person in control of the records who directly or indirectly knowingly denied access to the records. If the requested records are posted on the association website or are available for download through an application on a mobile device, the association may fulfill its obligation under this paragraph by directing to the website or the application all persons authorized to request access. And I just want to say that's what most associations should be doing, is having a website, at least by now. So that way, if something comes up, you say, just go on the website, and you just upload the website. Everything's good. Everyone's happy. And you don't have to deal with people in your office. Section 718.1112. In response to a written request to inspect records, the association must simultaneously provide to the requester a checklist of all records made available for inspection and copying. The checklist must also identify any of the association's official records that were not made available to the requester. An association must maintain a checklist provided under this subparagraph for 7 years. An association delivering a checklist pursuant to this subparagraph creates a rebuttable presumption that the association has complied with this paragraph. So this was new. This was, I think they started this maybe last year or the year before. Because before, if somebody wanted to inspect the records, it's like, our records are in this storage bin, have at it. And that was a records request. However, now you have to do an actual checklist, which I think is great. I mean, again, more transparency is always a good thing. A director or member of the board or association, penalties for repeated offenses. A director of the board or association or community association manager who knowingly, willfully, and repeatedly violates subparagraphs 1 commits a misdemeanor of the second degree punishable as provided in Statute 775-082 or Statute 775-083 and must be removed from office and a vacancy declared. For purpose of this subparagraph, the term repeatedly means 2 or more violations within a 12-month period. Any person who knowingly or intentionally defaces or destroys accounting records that are required by this chapter to be maintained during the period for which such records are required to be maintained, or who knowingly or intentionally fails to create or maintain accounting records that are required to be created or maintained, with the intent of causing harm to the association or one or more of its members, commits a misdemeanor of the first degree punishable as provided in Statute 775-082 or Statute 775-083 is personally subject to a civil penalty pursuant to Statute 718-501 1D and must be removed from office and a vacancy declared. Penalties for repeated offenses: a person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist other persons with such avoidance or escape, commits a felony of the third degree, punishable as provided in Statute 775082, Statute 775083, or Statute 775084. It must be removed from office and a vacancy declared. So now they up the penalties for people who are willfully, omitting information and trying to hide things. I always tell my kids, if you have to lie to do it, you probably shouldn't do it at all. So that rule applies here too. The right to inspect records. The association shall maintain an adequate number of copies of declaration, articles of incorporation, bylaws, and rules, and all amendments to each of the foregoing, as well as the question and answer sheet as described in Statute 718-504, and year-end financial information required under this section on the condominium property to ensure their availability to unit owners and prospective purchasers, and may charge its actual cost for preparing and furnishing these documents to those requesting the documents. An association shall allow a member or his or her authorized representative to use a portable device, including a smartphone, tablet, portable scanner, or any other technology capable of scanning or taking photographs, to make an electronic copy of the official records in lieu of the association's providing the member or his or her authorized representative with a copy of such records. The association may not charge a member or his or her authorized representative for the use of a portable device. Notwithstanding this paragraph, the following records are not accessible to unit owners. These are any records protected by the lawyer-client privilege as described in Statute 9502, and any other record protected by the work product privilege, including a record prepared by an association attorney or prepared by the association's attorney, express direction, which reflects a mental impression, conclusion, litigation strategy, or legal theory of the attorney or the association, and which was prepared exclusively for civil or criminal litigation, or for adversarial administrative proceedings, or which was prepared in anticipation of such litigation or proceedings until the conclusion of the litigation or proceedings. More protected records include information obtained by an association in connection with the approval of the lease, sale, or other transfer of a unit, personal records of association or management company employees, including but not limited to disciplinary, payroll, health, and insurance records. For purpose of this subparagraph, the term personnel records does not include written employment agreements with an association employee or management company, or budgetary or financial records that indicate the compensation paid to an association employee. More protected records include medical records of unit owners, social security numbers, driver's license numbers, credit card numbers, email addresses, telephone numbers, facsimile numbers, emergency contact information, address of a unit owner other than as provided to fulfill the association's notice requirements, and other personal identifying information of any person, excluding the person's name, unit designation, mailing address, property address, and any address, email address, or facsimile number provided to the association to fulfill the association's notice requirement. Notwithstanding the restriction in this subparagraph, an association may print and distribute to unit owners a directory containing the name, unit address, and all telephone numbers of each unit owner. However, an owner may exclude his or her telephone numbers from the directory by so requesting in writing to the association. An owner may consent in writing to the disclosure of other contact information described in this subparagraph. The association is not liable for the inadvertent disclosure of information that is protected under this subparagraph if the information is included in an official record of the association and is voluntarily provided by an owner and not requested by the association. More protected records include electronic security measures that are used by the association to safeguard data, including passwords, the software and operating system used by the association, which allows the manipulation of data, even if the owner owns a copy of the same software used by association. The data is part of the official records of the association. All affirmative acknowledgements made pursuant to statute 718.121, subsection 4C. Q&A sheet. The association shall prepare a question and answer sheet as described in statute 718.504 and shall update it annually. The association or its authorized agent is not required to provide a prospective purchaser or lien holder with information about the condominium or the association other than information or documents required by this chapter to be made available or disclosed. The association or its authorized agent may charge a reasonable fee to the prospective purchaser, lien holder, or the current unit owner for providing good faith responses to requests for information by or on behalf of a prospective purchaser or lien holder, other than that required by law, if the fee does not exceed $150 plus the reasonable cost of photocopying and any attorney fees incurred by the association in connection with the response. And that's kind of why associations charge for Q&A sheets, questionnaires, that kind of stuff. And they usually take up a lot of time, so it makes sense. Yes, ma'am. Peggy.
Hi, I just wanted to make another comment regarding your website, either using it or getting one. You're supposed to have one if you have 25 units or more. And if you put all your files like this, your minutes, all these documents accessible, it saves a lot of time looking and going up, digging up old records or finding old boxes. I mean, let's face it, even 3 years, but 7 years and 10 years, that's a long time to keep records handy. And let it be less cumbersome by putting a file on your website. Vinteum can do that, and maybe they can help you with your website as well. But it just makes no sense not to have it on your website in a file.
Yeah, it's a digital world we live in, you know?
Mm-hmm.
So get your documents digitally. That's one of the best things, and one of the best things you can do for your association. And quite honestly, most owners prefer that. They don't like having to go to the office or having to go somewhere. They rather just go on the computer, go on their phone, go on their tablet. It's all right there. Good plug.
One thing, excuse me, one more thing is I know just from experience of working for a management company and finding new boards to manage, most of my boards were complaining that they can't ever get their financials. That's an excellent place to also put your financials. You can look at them monthly, annually, whenever you want to look at them as a resident. You can just pull them up on the website. So I think that would be a huge reason to have a website and a folder, and also make other folders. Architectural committee, there's so many things. I don't care if it's your gardening committee. Put the things in there, and maybe even put the members of the committee and their phone numbers on there, so that's handy. But there's so many ways to use that website, and financials are huge, and all these certificates, everything, same thing. So good luck with that.
Yeah, and I don't know, I'm not sure if they do it or not, but a big thing that's happening now is people are getting into electronic voting. So
Yes.
so even that's being done online. So instead of sending out these big packets of the second notice, the ballot, their resume, it's all done from the website too.
Perfect.
And you should be having a website. I mean, they first started this in 2018? I think that's when the law first came out, where you had to have a website, and look, it's 2025. Almost halfway done. Q&A sheet continued. An association and its authorized agent are not liable for providing such information in good faith pursuant to a written request if the person providing the information includes a written statement in substantially the following form. The response herein are made in good faith and to the best of my ability as to their accuracy. Managing your website. See, 2019, I said 2018. So by January 1st, 2019, an association managing a condominium with 150 or more units, which does not contain timeshare units, shall post digital copies of the documents specified in subparagraph 2 on its website, or make such documents available through an application that can be downloaded on a mobile device. The association's website or application must be an independent website, application, or web portal wholly owned and operated by the association, or a website, application, or web portal operated by a third-party provider with whom the association owns, leases, rents, or otherwise obtains the right to operate a web page, subpage, web portal, collection of subpages, or web portals, or an application which is dedicated to the association's activities and on which required notices, records, and documents may be posted or made available by the association. So you can either own it outright, or you could hire a contractor to manage it for you. Did you have another question, Peggy, or a comment? Managing website. The association's website or application must be accessible through the internet and must contain a subpage, web portal, or other protected electronic location that is inaccessible to the general public and accessible only to unit owners and employees of the association. That's kind of what I mentioned before, where you kind of have to have two websites in a way. One for, not literally two websites, but you have to have like two sides to the website. One for the public and then one just for owners, because it has to be inaccessible. Upon a unit owner's written request, the association must provide the unit owner with a username and a password to access to the protected sections of the association's website. Again, to the protected sections of the association's website or application which contain any notices, records, or documents that must be electronically provided. Go ahead, Peggy.
Just want to mention, instead of worrying about going back and forth to make your payments, put your link from your property management company on the front of your website, so it's handy. And that way your opening page, you just click the link, it takes you to your property management site if need be, and make your payments that way. You don't have to go into both, remember 2 passwords and so on. So there's a lot of things you can do. Put it in the chat box if you're interested in some sort of a class on how to use your websites with the various functions, and I'll put one together.
That's a good idea. We're still making pretty good time. We have around another like 50 minutes or so. Any Peggy, any questions, Jamie?
No questions at this time.
Okay. Yeah, we got past all the real interesting stuff, the elections, and that's the stuff people really like to talk about. Managing your website. A current copy of the following documents must be posted in digital format on the association's website or application. The recorded declaration of condominium of each condominium operated by the association and each amendment to each declaration. The recorded bylaws of the association and each amendment to the bylaws. The articles of incorporation of the association or other documents creating the association and each amendment to the articles of incorporation or other documents. The copy posted pursuant to this subparagraph must be a copy of the articles of incorporations filed with the Department of State. The rules of the association. You also must have a list of executed contracts or documents to which the association is a party of, or which under the association or the unit owners have an obligation or responsibility. And after bidding for the related materials, equipment, or services has closed a list of bids received by the association within the past year. So summaries of bids for materials, equipment, or services which exceed $500 must be maintained on the website or an application for 1 year. In lieu of summaries, complete copies of the bids may be posted. So if you had a bid for $499, they have to be posted on the website. According to this, no. But $500, a summary or a copy of the bid. But most people, honestly, they're just going to post a full copy of the bid. It's a lot easier than posting a summary. Yeah, Jamie.
Question, does a portal on the property management company's website qualify as the website for the association?
Absolutely, it does. So long as, again, when they go to it, they say that what association is for. You know, if you just go onto a random page and then it doesn't really have anything saying that it's your association, but it has a login, that might be kind of weird. It should specifically say, you know, you're logging into, you know, Cloud Association's website and this is what's happening. Any other questions?
Not for me, but Peggy's hand is up.
Oh, no, I think it's just up from last time. So we have 10 more slides, just about, well, 13. I think we're doing good. The annual budget required, so something else you have put on your website is the annual budget required by statute 718-112, subsection 2F, and the proposed budget to be considered at the annual meeting. The financial report required by subsection 13 and any monthly income or expense statement to be considered at a meeting, which is kind of what Peggy was saying before. There's a good opportunity to put, a good place to put all your financials, because that's always a pretty common complaint is we don't see the financials. Well, go to the website. The certification of each director required by statute 718-112, subsection 2D4B. All contracts or transactions between the association and any director, officer, corporation, firm, or association that is not affiliated, that is not an affiliated condominium association or any other entity in which an association director is also a director or officer and financially interested. Any contract or document regarding a conflict of interest or possible conflict of interest is as provided in statute 468-435, 468-436, 2B6, and 718-3027, subsection 3. The notice of any unit owner meeting and the agenda for the meeting as required by statute 718, 112, 2D3, no later than 14 days before the meeting. The notice must be posted in plain view on the front of the page, on the front page of the website or application, or on a separate subpage of the website or application labeled notices, which is conspicuously visible and linked from the front page. The association must also post on its website or application any document to be considered and voted on by the owners during the meeting or any other document listed on the agenda at least 17 days before the meeting, at which the document or the information within the document will be considered. Now, this is a big one because this is also new. Because before, if you had a meeting, you just had to post it 48 hours in advance. But now you have to post. Now you always had to post it on the website, but now you have to post your notice to the meeting 14 days in advance of the meeting. And if you're going to be reviewing any contracts, any bids, anything that you're going to be reviewing has to be posted on the website at least 7 days before the meeting, as is written right here. And it has to be conspicuously posted on the website as well. So either on the front page, so when they log in, bam, board meeting, this is the agenda, or it has to be on a separate folder that is also linked to the front page. So the whole concept of this is all about transparency, being transparent to your owners. There should be no secrets in association. They should be able to access this information and readily know what's happening. Peggy, did you raise your hand again? It just keeps popping up. That's why I keep stopping. All right, thank you. So back to managing your website. The inspection reports described in statute 553-899 and statute 718-301 4P, and any other inspection report relating to a structural or life safety inspection of condominium property. The association most recent structural integrity reserve study, if applicable, copies of all building permits issued for ongoing or planned construction, document accessibility. So the association shall ensure that the information and records described in paragraph C, which are not allowed to be accessible to unit owners, are not posted on the association's website or application. If protected information or information restricted from being accessible to unit owners is included in documents that are required to be posted on the association's website or application, the association shall ensure the information is redacted before posting the documents. Notwithstanding the foregoing, the association or its agent is not liable for disclosing information that is protected or restricted under this paragraph unless such disclosure was made with a knowing or intentional disregard of the protected or restricted nature of such information. The failure of the association to post information required under subparagraph 2 is not in and of itself sufficient to invalidate any action or decision of the association's board or its committees. Which I think is very important, because I know a lot of owners, they typically get upset if, let's say, a notice was posted late online, and rightly so. I'm not saying it's not rightly so. I'm just saying that if that does happen, that doesn't, as it says here, it doesn't invalidate any action or decision of the association board or its committees. Yes, Miss Jamie.
Question came in, if there is a COA and an HOA, will the HOA's website be sufficient?
If there's a COA and HOA, so if there's two separate associations,
Right,
one condominium, one HOA, I mean,
Yes.
I would say their condominium should have a website and their HOA should have a website. You know, it's because in a way they may share a space, but they're kind of like neighbors. You know, what your neighbor has doesn't mean you have it.
right.
So
The documents are going to be different. The
yeah.
financials should be different. One should not necessarily be visual to another. If not, everybody is in the COA, some are in an HOA.
Yeah, there are some properties I've seen where, you know, they're big. There's a master association, and inside that master association, you have an HOA side, and then you have a condominium side. Each side should have their own websites. You can't just rely on the HOA side and say go to them. You have to have your own. You're under different statutes. You're different. That's a good question. Obligations of owners and occupants, along with remedies. The association may levy reasonable fine for the failure of the owner of the unit or its occupant, licensee, or invitee to comply with any provision of the declaration, the association bylaws, or reasonable rules of the association. A fine may not become a lien against a unit. A fine may be levied by the board on the basis of each day of a continuing violation, with a single notice and opportunity for hearing before a committee as provided in paragraph B. However, the fine may not exceed $100 per violation or $1,000 in the aggregate. Or 2, an association may suspend for a reasonable period of time the right of an owner or a unit owner's tenant, guest, or invitee to use the common elements, common facilities, or any other association property for failure to comply with any provision of the declaration bylaws, or reasonable rules of the association. This paragraph does not apply to limited common elements intended to be used only by that unit. Common elements needed to access the unit, utility services provided to the unit, parking spaces, or elevators. So things like your pool, you know, rec room, billiards room, gym, you could stop them from using, but you can't stop them from taking the elevator. You can't stop them for using their guest spots or their, you know, or if they're using, let's say, their patio, you can't say, you can't use your patio, you can't use any of that. That would be hilarious if they tried, but you can't do it. And this is our final section, Module 4, bids and contracts. This section is a little bit more than 10 slides. We have a little bit more than 30 minutes, about 40 minutes. So I'm thinking we could either go through it, maybe answer any questions, or maybe we should take a little break again. What do you guys think?
I'd say keep going.
Okay, yeah, we're almost there, the home stretch.
Let's knock it out.
All right.
Can
So,
you, I have a question that says, can you please put the last slide back on?
this one? I'm gonna assume this one, because the next one is just a graphic.
So I'm assuming that's the slide she's gonna question on in a second.
Yeah. Are you gonna try to stop them from using their elevators? I'm joking. Obviously you're not, but.
Will you be providing all of the slides at the end of this class?
Yeah. I can do that. No problem at all. Just send me a request. I'll put my our email in the in the chat at the end if you want it. So bids and contracts is our final chapter. Contracts for products and services in writing bids exceptions. Associations with 10 or fewer units may opt out of the provisions of this section if 2/3 of unit owners vote to do so, which opt-out may be accomplished by proxy specifically setting forth the exception from this section. Bids, section 718.3026.1. All contracts as further described herein, or any contract that is not to be fully performed within 1 year after the making thereof, for the purchase, lease, or renting of materials or equipment to be used by the association in accomplishing its purposes under this chapter, and all contracts for the provision of services shall be in writing. If a contract for the purchase, lease, or renting of materials or equipment or for the provision of services requires payment by the association on behalf of any condominium operated by the association in the aggregate that exceeds 5% of the total annual budget of the association, including reserves. So this time they do include reserves, exceeds 5% of the total annual budget of the association, including reserves. The association shall obtain competitive bids for the materials, equipment, or services. Nothing contained herein shall be construed to require the association to accept the lowest bid. Notwithstanding the foregoing, contracts with employees of the association and contracts for attorney, accountant, and architect, community association manager, timeshare management firm, engineering, and landscape architect services are not subject to the provisions of this section. Nothing contained herein is intended to limit the ability of an association to obtain needed products and services in an emergency. This section shall not apply if the business entity with which the association desires to enter into a contract is the only source of supply within the county servicing the association. Nothing contained herein shall excuse a party contracting to provide maintenance or management services for compliance with statute 718.3025. Conflicts of interest. Now, this is always a good one. Directors and officers of a board of an association that is not a timeshare condominium association, and the relatives of such directors and officers must disclose to the board any activity that may reasonably be construed to be a conflict of interest. A rebuttable presumption of a conflict of interest exists if any of the following occurs without prior notice as required in subsection 5. And I stress prior notice because a lot of times people feel, oh, there's conflict of interest, we can't do it. That's not necessarily the case. It's all about disclosure. You have to openly disclose the conflict of interest at a board meeting, I like to say, and have it documented in the minutes as well. Because this is, again, without prior notice. So continuing on. A director or an officer or a relative of a director or an officer enters into a contract for goods or services with the association. A director or an officer or a relative of a director or an officer holds an interest in a corporation, limited liability corporation, partnership, limited liability partnership, or other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. How to handle a potential conflict of interest. If a director or an officer or a relative of a director or an officer proposes to engage in an activity that is a conflict of interest, as described in subsection 1, the proposed activity must be listed on and all contracts and transactional documents related to the proposed activity must be attached to the meeting agenda. The association shall comply with the requirements of statute 617.0832 and the disclosure required by statute 617.0832 shall be entered into the written minutes of the meeting. Approval of the contract or other transaction requires an affirmative vote of 2/3 of all other directors present. So all other directors. So obviously they can't vote on their own contract. That is a conflict of interest. But at the next regular or special meeting of the members, the existence of the contract or other transaction shall be disclosed to the members. Upon motion of any member, the contract or transaction shall be brought up for a vote and may be canceled by a majority vote of the members present. If the contract is canceled, okay, let me read that again. I flew through it. Upon motion of any member, the contract or transaction shall be brought up for a vote and may be canceled by a majority vote of the members present. If the contract is canceled, the association is only liable for the reasonable value of the goods and services provided up to the time of cancellation and is not liable for any termination fee, liquidated damages, or other form of penalty for such cancellation. Now, there must have been some nasty fights in the past for them to include that. I just want to say, I can imagine people trying to get hit with, $200,000 liquidated damages. I just think one of the main things I want to touch on is how it mentions that if there is a relative of a director or an officer, and it mentioned that it has to be, that proposed activity has to be attached to the meeting agenda. So when you're posting meeting agendas on the property, does that mean we have to post a contract? Yes, because it has to go together. So just keep them all. Most associations have like a cork board where they just put everything. So when you're putting out your notices for the meeting and you're putting it on your cork board and you have the agenda, if you're going to be reviewing contracts for an officer or a relative of an officer, that also should be posted on the cork board. Again, no secrets in condominiums. We're down to the final few slides. Any questions? Oof. So we may be ending a little early, like 30 minutes early or so, but I think that should be okay. So how to handle a potential conflict of interest, which we kind of touched on. This is continued. If the board votes against the proposed activity, the director or officer or the relative of the director or officer must notify the board in writing of his or her intention not to pursue the proposed activity or to withdraw from office. If the board finds that an officer or a director has violated this subsection, the officer or director shall be deemed removed from office. The vacancy shall be filled according to general law. So how to handle a potential conflict of interest: a director or an officer or a relative of a director or an officer who is party to or has an interest in an activity that is a possible conflict of interest, as described in subsection 1, may attend the meeting at which the activity is considered by the board and is authorized to make a presentation to the board regarding the activity. After the presentation, the director or officer and any relative of the director or officer must leave the meeting during the discussion of and the vote on the activity. A director or an officer who is a party to or has an interest in the activity must recuse himself or herself from the vote. The attendance of a director or an officer with a possible conflict of interest at the meeting of the board is sufficient to constitute a quorum for the meeting and the vote in his or her absence on the proposed activity. So I like this because it's very clear. You could have a presentation with a conflict of interest. So they attend the meeting, they could go to the meeting, they could speak on the meeting, they could then present to the board. But when it comes time to vote, not only does the conflict of interest have to leave the room, it says any relative of the director or officer must also leave the room. So, yes, Jamie?
I have two questions. One, I know we are not there, just want to get this into the conversation, but with more and more people smoking pot, how do the non-smokers enjoy their unit with clean air anymore? In this multi-unit condo, we all need to smell their smoke now. I, for one, get ill. I know more and more people are complaining. I heard many things. This must be coming up to your coming up more and more.
Yeah, I mean, we don't cover cannabis use in this presentation. Maybe Peggy could notate that. That may be something people want to talk about. And honestly, that's always been a really tough spot. and not just cannabis, even cigar smoke, cigarette smoke in general. Like, these are non-smoking buildings, but people have medical marijuana cards. People like to enjoy a cigar on their patio, and now it's going into your patio, it's going into your room. It's always very, very tough to handle. My personal opinion, again, you can probably ask your attorney. You get more, what do you say? You get more bees with honey than vinegar, something like that. So like maybe breach that conversation with your neighbor if they're nearby. Say, hey, I'm, your neighbor, and sometimes when I'm home, this bothers me. Maybe there could be some kind of, some resolution between you two that doesn't necessarily require the board or require the association and management to step in. And they could work something out that way.
And a very, very important question. Who do you recommend as a management company? So I'm going to answer that for you and say that Brian is the owner of a management company. And I hope that you have found this presentation very informative and realize how knowledgeable he is in the industry. And Peggy will be providing all of the sponsors and Brian's contact information. And certainly we hope that you utilize the people that are here today. No,
Very good. Go ahead.
that was just my 2-second vote for you.
No, that was great. I didn't want to answer it because it would have been a conflict of interest if I did,
Sure. But I can answer for you. You
Yeah,
have truly
absolutely.
presented your knowledge and capabilities in the industry and should be acknowledged as such.
Thank you very much. Like I said, we make a good team. So I think, what do they say? Behind every good man is a great woman.
There you go.
Agreed.
You ladies are kicking butt. You ladies are really doing a good job.
One more. I think this is a comment. Great question on pot. We had a situation in our complex who consumed medical marijuana. However, the smell permeated down to the condo below. The manager spoke with the offending owner and they decided to sell and buy a house.
Yeah, it's
people have choices, right?
And I will say I don't smoke. I don't have a medical card, and it's a very pungent smell, and it permeates so well. Like it just kind of goes through everything. So I get it. And if you don't, but now in today's world, man, sometimes I'm driving and the car next to me reeks of it. I'm like, my God, like how? That's the world we live in. We gotta make decisions. And this is my last slide. So the last slide.
I still have 2 more on this topic.
Okay, I'll leave it here. We got time.
Hold on. Something came in and I lost it. Hold on can we stop medical marijuana if someone needs it for his pain?
Well, it's like asking if you could stop their wheelchair from entering, because it's messing up your floors. At this point, it's a medical device. They need it. So if they need it, you can't stop it. If somebody's coming in crutches, can we stop them from entering with crutches? Because it may be a hazard to somebody else if they fall on them. Very questionable examples, but if it's a medical need, you can't infringe upon that.
Hold on, I have 2 more. I think, well, he wrote Daniel, but I think he means Brian, needs to be commended for his excellent customer service and his knowledge is top notch.
Oh, thank you. I appreciate it. Man.
Next question. What can you do when you have one board member that is causing lots of issues within the other board members and is sharing confidential association business to owners? And I think a second question from that same, what to do when board member has a family member suing the association? Is that a conflict of interest? Can they still get the same information that other members? The board is skeptical about discussing anything else in fear that the information should be used against the membership. How should we go about this? There was a lot in that, and I think I'll answer for you. I think it's contact your attorney.
Mm-hmm. Yeah, that's an interesting one. Contact your attorney for sure.
And that's all I see at the moment.
Okay. So last slide, we made it through 4 hours of this just about. How to handle, it ends with this slide, a contract. A contract entered into between a director or an officer or a relative of a director or an officer in the association, which is not a timeshare condominium association, that has not been properly disclosed as a conflict of interest or potential conflict of interest as required by this section, or section 617.832 is voidable and terminates upon the filing of a written notice terminating the contract with the board of directors, which contains the consent of at least 20% of the voting interest of the association. As used in this section, the term relative means a relative within the third degree of consanguinity by blood or marriage. So that's like a relative third removed. And that's it. So I think if we have any more questions, friendly banter. Oh, my timer just went off too. So I'm going to stop my share now, Peggy, because we're just about done.
I have another question from the group. I need clarification on the use of proxies to elect directors for the board. According to the information I get on the web, Florida Condominium Act, applicable to condominium association, provides that proxies may not be used in the election of directors. The Condominium Act further provides that, except as otherwise provided in the act, members may not vote by general proxy. You said they can use proxies, but did I misunderstand what you said, or are they legal?
This may, I mean, it sounds like it's really something for their attorney. So I probably may just leave it at that. Because most proxies, like I said, there's no limit to who can hold a proxy. If you're not going to attend the meeting, you could appoint the proxies are used to appoint somebody to vote on your behalf. So if for example, if I had your proxy, Jamie, now I technically have 2 votes. So if I vote for somebody, that's 2 votes for them. But that's typically how it works. And I could have, and as many owners or whatever they like could appoint me to be their proxy.
Okay, so here's a question about a self-managed association. If an association is self-managed, does it require anyone on the board to have a CAM license?
No, nothing like that. If you're gonna hire somebody, they have to be a CAM.
What are the responsibilities for a secretary on the board?
That would be in your condo docs, what the responsibilities are. Typically, the secretary works as like the record keeper, so they're taking the minutes. They're the one, again, what we mentioned here, they're kind of taking the notices from the board members. So when the board does their certification course like this, you should give it to your secretary to maintain it, or your manager. That's kind of what you have a manager for. They kind of fill in a lot of those roles that a secretary would be doing otherwise. But if you look in your condo docs, it will specify word for word what the role of the secretary should be for that association.
I'm not sure I understand this one, so I'm going to reach out to Melvin. Melvin, I'm going to read your question, but I think you need to, if you would be so kind as to write it again with clarity. What he wrote was, what would you do if a board member elected on the board that is in violation with Canberra on the common area of the property, such as on the building? I personally didn't understand that. So Brian, if you don't either, then I'm going to ask Melvin if you could restate your question, please. Lots of questions, or I should say comments coming in for copies of the slides. Peggy will be providing slides to everyone in attendance within the next 24 to 48 hours with your sponsor list, as well as your certificate for the class. We have another comment from Wayne. Excellent presentation. Job well done by all. Thank you. Carmen, thank you for the information. Can we log off? Will we get confirmation via email? The answer is yes. Wayne said, excellent presentation. Well done. Thank you all. Mike Fazio, what a great session. Thank you. Beatrice, thank you. Aaron, thank you. Very informative from Bonnie. Okay, I have a question, Brian. Can you elaborate on the exceptions to the competitive bid requirements for contracts exceeding 5% of the annual budget? What about property insurance? What about landscaping?
So 5%. So let's say you're and I'm so bad at simple math now because all I use is AI and calculators. But 5%, you have your annual budget, right? And just to keep it easy, I'm gonna say $100. There's no budget that's $100, but just because it's very simple for me to use. Let's say your budget is $100, and in that $100 for the year, that is basically what you're doing for. That's how you're paying all your bills, right? 5% of $100 is what, $5? So if you have to get a bid for anything and it's over $5, you'd have to get multiple bids because it's more than 5%. Anything under 5%, you're not required to get additional bids, at least by the statute. Your rules and regulations, your condo docs may say something else. However, that's as based on the statute, that's where that threshold is. So if you get anything under 5%, you don't need additional bids. I thought it was pretty self-explanatory, but that still is a good question, though.
From Lynette, great job. Been an active board member for 7 years and still found this very informative. Thank you, everyone. Look forward to the slides and sponsor contacts. All the best. Treasurer at Creek Club number 3 condo.
You're very welcome, everyone. I'm glad they enjoyed it. I told you it's an informative, presentation. It's long. I'm thirsty, but it was good.
Okay, a couple more. If you're still with me.
Yeah.
How much general maintenance do we have to maintain? 2 years of litigation going on with a sinkhole.
I'm not even sure. Sounds like there's a whole lot of stuff for that one.
Yeah, I think that's a call your attorney question.
Yeah.
Is a director and officer's insurance policy required, and when would you need to use that policy?
Yeah, D&O is, I mean, I don't know if it's required, but I don't know why you wouldn't want to have it.
Good business practice.
Yeah, because otherwise you're personally liable for everything that happens, even if you're acting in the facet of a board member. Because the whole purpose of D&O is, let's say you make a decision that was a very bad decision, but you did your best you can and you were wrong. Instead of suing you, they could sue you, but you could turn over to your D&O and say, look, I just made my decision as a board president because I thought it would work out for everybody, whatever it may be. I made a very prudent decision based off of extenuating factors. Who knows? But I would never recommend to not have D&O. I'll say that.
Couple more questions still coming in. What are the exceptions to the competitive bid requirements?
What were you going to say, Peggy?
I just wanted to tell you a quick story on this D&O, and that is committees are also covered under your D&O besides the boards. And if you have someone, and this happened, where someone's, let's say, working on the garden committee and they cut their finger off, they are going to sue the association because it's an association committee, or they might, And you can actually use your DNO for that. So there's other things besides complaints and things like that. You didn't do this right, you didn't do that right, but there's actually medical situations and sometimes physical situations that you would want to definitely, have that policy. And it's kind of like a flood insurance policy. It's not that expensive. It's a
Yeah.
rider, and it's very, very useful. So don't skimp on that.
Yeah, that is some extreme gardening. Hope nobody ever lost their finger from that, but yeah.
I don't know. I was in the weeds today with all these garden comments. I don't know why, but
No, maybe we need to do some gardening to unwind now. I tend to my garden as much as I can.
Okay, I still have questions rolling in.
Okay.
What are the exceptions to the competitive bid requirements?
What was it? It was under 5%. That's basically what it's saying. So it's under 5%, you don't have to get competitive bids. Over 5%, then you have to get competitive bids, but you don't have to go with the lowest bid. It did say that. So just keep an eye out for your budget. And it's honestly, in my opinion, 5% is kind of high, especially when a lot of these association condominiums, they're operating on $1 million budget, $2 million budget. 5% would be what, $50,000. So a lot of times it's a lot of money. So just because you don't have to do it, like statutorily speaking, doesn't mean again you shouldn't. Like good practice, that at least a lot of the clients that we have, anything over like $2,000, we get competitive bids for. You don't want to do it too much because then it delays everything before you know it. But at the same time, you want to protect the association. So you don't have to stick to 5%. You could change it to whatever you feel your association would be okay for. Me personally, most associations, they get more bids if it's over, like I say, a couple $1,000s, they'll get an additional bid. And of course, like
Oops, sorry.
No, I was going to say, and of course, the kind of work they're doing, but that's a whole other topic.
Next question, who should be the point of contact for the attorney? Can any board member just reach out anytime?
Yeah, it depends what you have, but it depends what contract you have with your attorney. I know a lot of attorneys, they may have it written in there that they will only take direction from an officer of the board, not a director of the board. But sometimes I do see it where they just have a contract with the association. So any representative of the association, whether it's a CAM, the president, the treasurer, the secretary, a director, anybody, they could call the attorney and ask a question. Of course, that's a conversation you could have with your board, conversation you could have with your attorney, and you could say, hey, look, we want to cut back so that way, or maybe not cut back, but we want to change things so that way you can only take calls from this, this person, this officer, this director, or this manager, and that's it. That, to me, is the best way to do it. Keep it streamlined.
Right, and they could make a motion in a board meeting so that it's in the minutes who is the authorized contact for the attorney.
Yeah, that's the best way to do it. The name of the game in condominiums is efficiency, because you have so many board members and so many owners, and everybody has an opinion and everybody knows what's best, that if you don't take control, your fees are going to go run rampant because everybody wants to talk to the attorney, and then nothing will get done because everybody's going to the manager and they're being pulled 1,000 ways. If you could put everything in a nice, simple, streamlined, who's communicating with who, updates are received at this date, and that takes some self-discipline as well. You have to trust the people that you're with to take care of it. Then that minimizes a lot of confusion in the future.
Next question, sorry. If the former president/secretary left the development and did not leave proper documentation of anything done during their time on the board, what should we do?
If the former president/secretary
left the development and did not leave proper documentation of anything done during their time on the board, what should we do?
I mean, again, maybe an attorney question. Send a demand letter. and say, hey, we need this, you have it, go from there.
I'm assuming that's a self-managed association, because if it was with a management company, all the documents should be in one place, but
Correct. Correct.
Next question regarding oh, and that gentleman wrote back, yes, they are self-managed. So yes, then you're going to need to contact your attorney, as Brian said, for a demand letter of the documents.
And that doesn't mean you'll get it, really, because he could still come back and say, look, I gave him everything, I have nothing else.
Correct.
Now you're left with the question, do you still want to pursue this and potentially sue them, or you just want to move on and try to move forward? Maybe
And
best to move on.
to clarify that, documents, I believe the law says that documents available that exist, right? So if the
Yeah.
association shows that they attempted to obtain documents and they were unable to, that's the answer to those missing documents, correct?
Yeah, that too. You made a best interest in trying to, get these documents.
Another question regarding the 5%. What if, for example, you have an elevator maintenance contract with a company, but there is a breakdown that results in a repair replacement cost greater than 5%? You can get other bids, but you're sort of locked into your service provider. Thoughts?
Yeah, I mean, if you're locked in with your service provider, again, this may be something with your attorney, but if you're locked in with your service provider, you may just have to go with them. Elevators, and not for nothing, elevators typically could be deemed an emergency situation. There's elderly people, there's handicapped people, people who need the elevator to work. And if this is how much it costs, because let's say your pump blew or the control blew, something blew, whatever it may be, and you got to do it, you got to get it replaced. It is what it is.
Next question. Can you recommend an insurance agent for the D&O policy?
Don't we have one on this call? I think one of those calls.
LT Area is a public adjuster.
Okay, so
He
maybe
doesn't do regular insurance.
No, we have COA Solutions,
Oh,
Yeah.
okay.
Daniel Baum.
Got a referral for him right there.
So Daniel's information will be in the sponsor sheet that's provided after this class. And the other question, I don't know if Daniel, I see him on the banner, but I don't know if he's still on the call. Can I force the board to get D&O to protect board members?
I mean, you as an owner can't really force anything. A collective of owners can, or if you want to join the board, then you can, but that's the only way to do it.
Comment, Daniel with COA is awesome. He's highly recommended. So there's another kudos to one of our sponsors.
Good job, Daniel.
I don't see any other questions or comment. Whoops, I lied. Oh, no, just didn't dismiss that one. Sorry. I don't see any open questions or comments. Does anyone else have anything else, or Peggy can wrap up the class?
All right, I think back to you, Miss Peggy.
Okay, wow, a lot of information, and I've already been on 3 of these, so I'm still picking up things. So great presentation, like everyone's saying, Brian. Thank you to Jamie for moderating again. I want to thank everyone on the call attending, and especially the sponsors who invited you. I have some upcoming webinars and things you might want to hear about. On March 24th, next week, I've got Karen's Engineering talking about mitigating and managing the deterioration of aging buildings. It's a 2-hour CEU course, very intense, very informative. So I'm sure you would want to hear about that. If you don't have problems now, at least you have some knowledge about what you can or have to do in a situation. Then I have Dahlia Anise, one of our sponsors today, who's going to open up on April 1st. She's going to be speaking on wills, trusts, and incapacity planning. It is a 1-hour course, and it does open up to a lot of questions, legal questions. So coming up on the radar, I have, just to finalize some of the dates, I have Benjamin Moore, everything you want to know about painting projects on your buildings. The paving lady is going to give a paving class either end of April or early of May on paving techniques and budgeting. I do have an HOA board certification class coming by Jane Boland sometime during the month. I am working on a series of Spanish classes for board training, as well as just starting some webinars on a regular basis, maybe one a month or one every other month for Spanish speaking board members. I'm going to try to make sure they are also CEU courses. And I know Karen's Engineering does give classes in Spanish as well. So the next one also is Jane Boland's going to give a class on transparency, the new law. I do have a Hurricane Awareness Summit coming up in partnership with COA Solutions and Clarkson and Varick Elevator Company. The attorney and the engineering companies will be also added to the panel, and we're targeting early May. Lastly, I wanted to mention that J.R. Frazier is presenting a Sears course, Planning and Expectations of the Boards and the CAMs to Manage Your Reserves. That is going to be out probably mid-May. So watch for the flyers. Congratulations, board members, today for taking the course and finishing it to its completion. I want to thank everyone again, and I hope to see you on the next webinar. Thank you.